Assalamu alaikum students, be ready. Para. The above case is on all fours, comma, as discussed above, full stop, along with the statement of claim filed on behalf of the respondents. A copy of the agreement was also filed and marked as annexure P1, which we are, comma, therefore, comma, entitled to look into, and we have done accordingly, full stop. Para. This brings us to directly the question raised in the appeal with regard to the interpretation of default clause 6 of the agreement, full stop. It was the case of the respondents themselves that they were entitled to claim damages on the basis of the provision contained in the clause itself, which was covered under the head inverted comma other charges inverted comma full stop. Not only this, the respondents had conceded before the High Court that the award could be remitted to the arbitrator to determine the damages on the basis of the market price, because admittedly no notice in writing was given as required under section 54 of the Sales of Goods Act before the resale of the goods, full stop. The respondents, comma, therefore, comma, are bound by their own admissions, and the question of law which arises is whether the default clause was exhaustive of all contingencies following the breach of the agreement, full stop. The answer to this question in our view must be in the affirmative, but because no provision of damages is to be found in the agreement, full stop. In this view of the matter, we are unable to agree with the finding of the learned judge in the High Court that the damages were permitted by law when outside the scope of clause 6 of the agreement, full stop. It has been held by this court in the case of West Pakistan Industrial Development Corporation versus Aziz Qureshi that according to well settled principle, a stipulation not expressed in a written contract should not be implied merely because the court think that it would be a reasonable thing to imply it, full stop. Such an implication can be made only if, comma, on a consideration of the terms of the contract is a reasonable and business manner, comma, the court is satisfied that it should necessarily have been intended by the parties when the contract was made, full stop. Para. Having gone thus far, it is now left for us to examine contention raised on behalf of the appellants that even if the case of the respondents on their own showing was covered under the head inverted comma other charges inverted comma, then to an amount over and above what was specified in the default clause could not be awarded to the respondents, full stop. As we have held that since no provision was made for the award of damages in the default clause, the case of the respondents must rest on the interpretation of the same, full stop. All contingencies, comma, including the cancellation of the agreement, comma, were well within the contemplation of the parties at the time of the drawing of the agreement, and there is much force in the argument raised by the learned counsel for the appellants that the arbitrator was not competent to import an agreement for the award of damages when none in fact was provided for or existed in the contract itself. Full stop.